Well, welcome out. It's my pleasure to welcome you on behalf of the Foley Institute to our event today. And the Foley Institute was established at WSU back in 1995 to has a threefold mission. It's to support public policy research, to get our students involved in public service, and then finally it is to provide programs of public education on important matters of public affairs and public concern. So it's really a core part of our mission to host these types of events and to have partners like the League of Women Voters, who we oftentimes do joint events with, and it's really it's our honor and privilege. We have a very distinguished panel today, and it should be a very lively discussion as we move ahead. What I will do is introduce our first panelist, and then I will introduce each succeeding panelist after that as well. Our first speaker today is Dr. James Gibson. Jim is the Sidney W. Sowers Professor of Government at Washington University in St. Louis. He is also a professor of African and African American Studies and the director of the program on citizenship and democratic values at the Wiedenbaum Center on the Economy, Government, and Public Policy. In South Africa, Jim holds the position, this is one that I'm envious of, it's entitled a Professor Extraordinary in Political Science.
Why are you all laughing?
At Stellenbosch University. Professor Gibson has published well over 100 journal articles and book chapters and 8 books, including the award-winning Overcoming Apartheid, Can Truth Reconcile a Divided Nation? His research has been recognized with numerous awards, including the 2005 Decade of Behavioral Research Award, and recently, in 2011, the Lifetime Achievement Award for the study of law and courts by the American Political Science Association. Jim earned his BA in political science from Emory University in 1972 and his PhD from the University of Iowa in 1975. Among his many substantive interests, he is currently conducting research on public reactions to the trials of the Khmer Rouge in Cambodia, on intolerance and perceptions of freedom in contemporary American political culture, on public reactions to spending in state judicial campaigns, and on the impact of judicial authority symbols on citizens' perceptions of the law and courts. Join me now in welcoming Jim Gibson.
Can you hear me okay? Can I raise it a little bit, do you think? Well, I think it'll be okay. Well, thank you very much, Cornell. It's a delight to be here, and I appreciate the Foley Institute and the League of Women Voters giving me the opportunity to come and talk to you a little bit about some of my research. I think I was asked to talk because I've done quite a bit of research on the question of the legitimacy of courts. I've looked at this issue extensively with regard to the United States Supreme Court. I've done quite a bit of work on state courts, in particular in West Virginia, Pennsylvania, and Kentucky. And I've done this sort of work all around the world for constitutional courts, and in particular in South Africa. So I know a little bit about the legitimacy of courts. However, I've got to start with a caveat, and that is I'm talking about appellate courts in every instance. My work does not extend to lower court judges, and it does not extend to legal authorities like the police. So I'm talking about institutions that are fairly far removed from the everyday lives of citizens. I should also say that I know less about diversity, and especially the impact of diversity on legitimacy, than I know about legitimacy itself. So my remarks are going to be a little bit tentative, and to an unusual degree, I'm going to rely upon research reported by other scholars on this issue. Now, the definition of legitimacy I use is that it is a grant of authority to decide important issues of public policy. So with this grant of authority comes the implication that citizens should accept decisions, including decisions with which they disagree. We know from the Federalist Papers that the judiciary is a weak branch, having neither the power of the sword nor the power of the purse, and therefore it's unusually dependent upon legitimacy to get compliance. I always say that legitimacy is for losers. And what I mean by that is people who win in public policy disputes rarely question the authority of the institution. It's the losers that we have to worry about. We have to worry about their compliance. We have to worry about their loyalty. We have to worry about their willingness to support the institution in the future. So I always use Bush versus Gore as the textbook case. And in fact, I've written extensively about Bush versus Gore. As it turns out, the U.S. Supreme Court has such a high store of legitimacy that Democrats accepted that opinion, in which George Bush became president. African Americans accepted that opinion, and there was no effort to launch a campaign of retribution against the court, except for a few crazy law professors. No campaign to punish the court for its decision because it was viewed as legitimate. Now, I've spent a lot of time measuring the legitimacy of courts, and we do so through surveys of public opinion. I've done surveys annually since '05 in this country, nationally representative samples, and because of this conference, I decided first to go and look at my own data and determine whether there were differences in support for the U.S. Supreme Court associated with one's gender and one's race. To my surprise, I found statistically significant differences on gender. Believe it or not, gender is usually a worthless variable in politics. The differences between men and women are not great, in part because women are heterogeneous, as are men. But here you can see, not a big difference, but you can see that men are more likely to extend legitimacy to the U.S. Supreme Court than are women. Similarly, there's substantial racial differences in these data, with this column over here being white Americans who exhibit a significantly higher degree of support for the U.S. Supreme Court than do blacks, Hispanics, and Asian Americans. Now, I got to be a little bit careful here. These are raw differences. They're not ceteris paribus. They do not control for class. They don't control for region. They don't control for anything. But nonetheless, they are statistically significant, and therefore, they're sort of the starting point for my thinking about whether lack of diversity has anything to do with these findings. Perhaps we ought to stop for a moment and actually look at the data on diversity. As it turns out, some of our colleagues have examined every appellate court judge in this country as to gender and race, and have done so since 1985. The red bar represents the non-white male portion of American state appellate court judges. And you can see that in 1985 it was low, round about 15%. In 1999 it jumped up to just above 25%, and today it's approaching 35%. From the blue part of the graph, you can see that the big difference is with regard to women, a dramatic rise of women in the judiciary, and the relative stagnation of African Americans on the bench. So a couple of conclusions come from this. There have been significant increases mainly with regard to women, but there's still very substantial underrepresentation on the bench with regard to gender and race. So the hypothesis that I'm interested in thinking about is whether support is dependent upon a diversity. I myself have conducted no research on this particular issue, but it turns out that some of my colleagues have published a paper very recently on precisely this issue. And so I thought I'd share with you the results of that research. Now, political science is a statistical science, has been for a long time, but you probably know that the Achilles heel of statistics is causation. We can establish that things go together. To establish that X causes Y is actually much, much more difficult. So political science as a discipline has moved into methodologies that involve experimentation, very much like the medical experiments that you read about in the newspaper. So this is a study that randomly assigned people to hear one of three kinds of stories about the representation of African Americans on the federal judiciary. This is a study that can claim ceteris paribus, and so the claim to causality is actually much stronger than in ordinary statistical work. So we've got three groups. First group is asked to read a story that says that blacks are underrepresented on the federal judiciary. The second group reads a story that says blacks are overrepresented, and the third reads a story that talks about judges but does not mention race. Among African Americans, you can see that these three conditions have a big impact on their willingness to grant legitimacy to the U.S. Supreme Court. The small bar is the control group. No article is read. The middle one says that blacks are underrepresented, and the last one says that they're overrepresented. So this is evidence that to the extent that black people understand that members of their race are proportionately represented on the bench, legitimacy rises. But here's the other side of the coin. This is the white respondents. Almost a mirror image going in the opposite direction. And that is when whites are told that blacks are overrepresented, their support for the U.S. Supreme Court is at its lowest. Now that's an important finding, I think, for you and for us as scholars. Because what it means is that when you put the white sample and the black sample back together, and let's just say majorities are 75% in this country, minorities 25%. When you put them back together, this study strongly argues that increasing diversity will lower the overall level of legitimacy of the judiciary. I think that's a worrisome finding. Now, don't get me wrong. This is a survey, intercept survey of people hanging around in Penn Central in New York. It's a little bit more scientific than that, but only a fraction more. But God knows what would happen if we did this survey in Mississippi. So it's a very worrisome finding to suggest that increasing diversity could wind up hurting the legitimacy of courts. Now, this article has caused me to think a little bit about the process by which legitimacy and diversity are connected, and I thought about some conditions that might be important. The first is we have to have group identities. And you probably know that there's a body of research showing that African Americans believe strongly in a sense of what's called linked fate that gives them a group identity that allows a diversity to become an important group characteristic. Women much less so, but still not completely devoid of group identities. So some have written about the intrinsic value of a group representation, and they've talked about things like the increase in group pride that might result from having members of their race or gender on the bench. I find it difficult to map that kind of pride onto institutions. That may be what's happening, but I rather think that the process is more extrinsic in the sense that when one sees a member of one's group, a level of trust is raised, and people come to believe that the office holder will do the right thing from the point of view of the members of the group. So I find that theory much easier to connect to courts and to questions of the style of judging that might be associated with members of different races. Let me give you a little bit of sense of what I mean by this styles of judging. During the Sotomayor nomination, President Obama weighed in on the kind of judge that he wanted, and he said, "We need somebody who's got the heart, the empathy to recognize that what it's like to be a young teenage mom, the empathy to understand what it's like to be poor or African American or gay or disabled or old. And that's the criterion by which I'll be selecting my judges. This is an empathetic model of judging. John Roberts said when he was being confirmed that judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it's a limited role. Nobody ever went to a ball game to see the umpire. So we've got empathy on the one hand, umpire on the other. Interestingly enough, there's a book by an umpire in which he says, when he's talking about calling balls and strikes, that the strike zone is kind of like the Constitution. The strike zone is a living, breathing document. So this umpire at least had a somewhat different view than Mr. Justice Roberts on the nature of judging. So we've tried to turn this into a question of what the American people are interested in their judges. Are they more desirous of judges who have empathy, or would they prefer that they have umpires? We've asked questions about a lot of characteristics of judges. I know you can't read this. I'll show you why it's up here in a second. A lot of characteristics of judges, and these are the percentage of people who believe the characteristics are very important for a judge to have. The two most extreme are uphold the framers' values. 74% of the people believe that that's an important characteristic for a judge. By the way, I do not necessarily take this as an endorsement for the views of white males who are tolerant of slavery. I think the respondents were probably thinking of something else when they thought about the framers. But the second is this empathy characteristic, with fully 2/3 of the American people believing that that's a very important characteristic for the judges. Just in comparison, the more umpirish characteristic of strictly following the law is endorsed by just over half of the American people. So if people expect empathy, and they believe that they're more likely to get empathy from a co-ethnic, a member of their group, their gender or race, then in fact diversity will lead to the satisfaction of expectations and the raising of the legitimacy of courts. So the crucial link, at least from my perspective, runs through styles of decision making. Diversity, therefore, will necessarily result in different decisions being made by courts. It's not simply a matter of symbolic representation. It's going to change public policy as well. So the question is, do blacks support the U.S. Supreme Court more because Clarence Thomas is on the court? Well, I doubt it. Clarence Thomas is among the most conservative judges who's ever sat on the U.S. Supreme Court. Do women support the Supreme Court because of Sandra Day O'Connor? A better argument can be made there. O'Connor's very, very conservative, of course, but O'Connor is balanced by Ginsburg, and so women can find an ideological mate on the Supreme Court. So I believe that when we start talking about diversity, we just can't ignore the role of ideology. We've got to include ideology in this equation. So I've thought about this a little bit more. Judges need to be like me, but they must also be accountable for their decisions. For the diversity to lead to legitimacy, there must be some form of accountability for decision making. And therefore, the key question is, does accountability for courts affect their level of legitimacy? Now, I know that in this room, and especially these guys, accountability is a dirty word. And it's a dirty word to professors as well. None of us want to be accountable. But the American people, I believe, are different. They do seek accountability from all political institutions, including the judiciary. As it turns out, I've done a lot of work on this issue. And the work is in the context of looking at the effect of campaigns on the legitimacy of state courts. A lot of people are complaining about campaigns involving attack ads, campaign contributions, policy pronouncements, etc. The current the poster child is, of course, Wisconsin, and they're worried that these kinds of campaigns will undermine the legitimacy of courts. Turns out I have a book coming out on this issue. You'll see I have no conflict. If you knew anything about the royalties that professors get for the books that they write, I have no conflict of interest in telling you all about this book. But it is a study of one state. It's the study of Kentucky. And it tries to assess what impact the 2006 campaign had on the legitimacy of the Kentucky Supreme Court. And I'll just very, very briefly show you the findings. I developed what I called an index of ad churlishness. University of Chicago Press was not wild about churlishness, but I prevailed on this one. And this is exposure to negativity, to partisanship, to unfairness, and to inappropriateness in ad campaigns run during a judicial election. Now, if you look at this, this is change in legitimacy. So people, the far bar over there, the big one, shows that people who were exposed to very few churlish ads increased rather substantially their support for the Kentucky Supreme Court. Now, you'll see that the bars go down. So the ad campaigns do damage. They do damage to the court. But what you'll also see at the highest level of ad churlishness, that the effect of the election is approximately zero. So even under the worst possible conditions, and this applies to a tiny proportion of the sample, even under the worst possible conditions, the legitimacy of the court is not damaged. Same thing for Pennsylvania. We showed them 3 kinds of ads, and the big bar is the control group that were exposed to no ad. Well, what this is showing is that elections, ipso facto, generate legitimacy for courts. Can that increase be diminished by the activities of the campaign? You bet it can. But the net, at the end of the day, the net is positive, and therefore the legitimacy of the court is enhanced. So we've shown this in at least 2 states. I know I'm about out of time, so let me wind up with some conclusions. The first thing that I think we need to think about when we think about this topic is whether there is, in fact, a problem of legitimacy. I think we need to do studies to determine whether minorities are less willing to support the Washington Supreme Court. We don't have the evidence. We don't know that there are problems out there that need to be solved. If there are, I think we ought to think about raising the accountability of judges. Perhaps we ought to get, perhaps one way to do it is to get judges to think about themselves as representatives of a community, of a subset of the electorate. But as I've suggested to you, there may be a backlash. It requires typicality. Governor Christie of New Jersey just nominated a black Republican gay guy to the New Jersey Supreme Court. He had picked from a total of 3 to find this person. And he, in fact, the guy had no trial experience, never been in a courtroom, and New Jersey said no to him just this past week. You can't increase diversity and legitimacy by selecting candidates that are atypical. And so this whole thing is, I think, a very difficult pathway. But are there other means of fostering a sense of accountability? You know, perhaps we could get judges to think of themselves just a little bit more as representatives, as being accountable to their constituents. And I would put forth the model of Sir Edmund Burke, the trustee model of representation, in which the judge still maintains a certain amount of accountability, of independence from the constituency, but nonetheless takes the values of the constituents into account in making decisions. This is a famous model. Everyone forgets, however, that Burke made this speech to the electors of Bristol and then was promptly voted out of office. So this may not be the world's greatest. And so one aspect of this might be outreach. It might be cameras. It might be judges getting out and getting to know their constituents much better. Finally, one of the important findings that we have that I haven't talked about is very simply that to know courts is to love them. And what I mean by that is the biggest supporters of the legitimacy of courts are people who know more about courts. And so, especially in this group, it might be useful to think about ways in which we can teach people about the nature of the judiciary. I'm not talking about umpires. The American people don't buy judges or umpires. But they do recognize that judicial politics is different than ordinary politics. There's something different between the Supreme Court and the legislature. And I believe that judges can do a lot more to try to educate people on what that difference is and why it's so important. Maybe the bottom line, the only real thing that you ought to take away from this is that increasing diversity in the judiciary may very well have substantial cost. And when we think about diversity, therefore, we've got to think about ways in which these costs to judicial legitimacy can be minimized. I've suggested some, but I'm sure y'all can think of much better ones. Thank you.
Perfect on time. All right, our next panelist is Justice Stephen Gonzalez. Justice Gonzalez was appointed to the Washington Supreme Court in January of 2012. Before joining the Supreme Court, Justice Gonzalez served for 10 years as a trial judge on the King County Superior Court, as well as an assistant U.S. attorney in the Western District of Washington, and as a domestic violence prosecutor for the city of Seattle. He also previously worked as an associate in the business law department at the Seattle law firm of Hills, Clark, Martin, and Peterson. Justice Gonzalez has received numerous awards throughout his distinguished career, including Judge of the Year awards from the Washington State Bar Association, the Washington chapter of the American Board of Trial Advocates, and the Asian Bar Association of Washington. Justice Gonzalez earned his B.A. in East Asian Studies from Pitzer College in Los Angeles and his J.D. from the University of California at Berkeley Hall, where he also served as the technical editor of the La Raza Law Journal. In 2011, Justice Gonzalez received an honorary degree from Gonzaga University School of Law, where he also delivered the commencement address. Join me now in welcoming Justice Gonzalez.
Well, good afternoon. Thank you for hosting us here. I'm going to be a little bit provocative with you, if that's all right. Let me ask a question to start off. Who thinks that I start at a disadvantage in a statewide election in the state of Washington because my last name is Gonzalez? Who thinks I'm not at a disadvantage because of that? All right. Now, if it's true that I'm at a disadvantage with a Latino surname, is that justice, I propose to you? And I suggest that it is not. When I considered putting my name in for appointment to the Supreme Court, the pollsters sat me down and said, in King County, you're 3 percentage points behind because your last name is Hispanic. Outside of King County, it's far worse. With that daunting prospect in front of me, that is having to make up percentage points, and 3 percentage points is a landslide in an election. Should I have put my name in? Should a person of color who faces that try to be elected by this electorate that, according to the poll, discriminates against me just because of my heritage? Absolutely I should. Because we're going to change that if in fact it's true. Because you're going to help me educate this state that I'm the superior candidate. Because if we address this race on the merits, I win. It's not even close. And I don't say that boastfully. I'm rated exceptionally well qualified by 7 bar associations. He hasn't bothered to be rated. He put up a web page that says, the Constitution should not be a living, breathing document. Voters should not settle for a judge who's been appointed by the most partisan office of the state. Personally attacking me, it goes on, violating the canons of judicial conduct. That's my opponent, yet he starts ahead of me because his name is not an ethnic name. That is not justice, and we will not let that stand. Now, that's how I start. Let me move to a story. A few years ago, 2009, the King County chapter of Washington Women Lawyers called me up to say that they were going to give me the Vanguard Award. I was pretty pleased with that call, and I rushed home, and before helping with the kids or anything at the house, I bragged about it to my wife, and she said, Steve, that award is for people on the cutting edge of women's issues. It must be aspirational. So, my family keeps me humble. They've taken on that task with great enthusiasm at home. So, let's talk about accountability. There is a bar poll in King County where I was a trial court judge for 10 years, and my marks are very good. In fact, in the category of administration of the judicial branch, I got more exceptional marks than any of the other 52 judges. We heard from the professor this assertion that we need more research to find out whether minority and ethnic groups have lack of faith in our judicial system. Of course they do. We don't need research for that, Professor, with all due respect. Ask the minority communities if they respect it. Look at the results of the jury summons and how many people of color come in and respond or simply forsake the judicial system and don't do it. Think what happens when you have a Supreme Court justice making statements about race that undermines the very legitimacy and faith that communities of color have. Think what happens when we look at the rates of incarceration for people of color and people say, well, that's just fair. People committed crimes, that's why they're there. Let's take an example and debunk the myth. The assertion by a justice was that people of color are in prison more because they commit more crimes and they commit them against each other. Let's look at drug use. Drug use is the same regardless of ethnic group. Drug dealing is in fact higher for whites. But you're 33 times more likely to get arrested for drugs if you're a person of color in Seattle. How do you explain that? All right, maybe there are legitimate reasons for some of that differential. Poverty, perhaps. Drug usage. Maybe the laws passed by the legislature affect that, or facially neutral policies that are applied in a way that are not fair. But to simply say the people are there, deserve it, and there's no issue of racial disparity that we need to address as a society is to bury your head in the sand. Of course, there's a problem with legitimacy on our court. Now, I get asked by reporters all the time, are you going to make different decisions because of your ethnic background? Now, I'm sure what they're asking is, will my decisions be different because I'm the only Jew on the Supreme Court? That must be what they're asking. I am, by the way. But I wonder if all Supreme Court justices get asked that question. And what are the inherent assumptions in the asking of it? I ask you to consider that. I want to tell another story. When I was on the Superior Court bench, this is about 8 years ago, one of our neighbors asked our son to describe what his dad does. And he said, my dad wears a black dress and speaks in a microphone. And I want to tell you, I was too proud of him to speak. My first job, I grew up in a family without much. My first job was cleaning park restrooms, and that's why I knew I needed to stay in school, because I didn't want to keep having to do that. And if you've ever cleaned a public restroom, you know what I'm talking about. So I was the first to go to college and the first to go to law school. When I decided to go to college, I grew up in a college town, but I didn't have any connection with them, and my high school counselor was not a help to me. So I went into the first college and I asked for an application, and the woman behind the desk said, well, is that for you? And I got a chip on my shoulder, and I thought, well, she's saying I shouldn't be applying. I said, of course it's for me. She said, well, Scripps is a women's college. So I got a little embarrassed, but then I really wanted to go to Scripps. I walked down to the next college, which was Pitzer. I was 16 years old at the time, about to start my senior year, and I applied there, and that's where I went. I majored in East Asian Studies. I speak Japanese and Chinese. I've studied in both countries, including graduate work in Japan in economics. When I started at that school, my grandmother had just gotten laid off from her factory job, and she was hired on as one of the dorm cleaners at Pitzer College where I worked. So I lived in the dorm where my grandmother was on the cleaning staff. And I saw how my fellow students treated workers. And it was a very valuable lesson. So we've talked a bit about the polls and about my ethnic background, and I'm sure you're gathering that I think diversity matters on our courts. And I think it matters for two reasons. So I would never stand before you and claim that I'm qualified to be on the court because of my ethnic background. I'm not. I'm qualified to be there because of my 10 years experience. I'm the only former Superior Court judge on the Supreme Court right now. The awards and recognition I've gotten, those things, my education at UC Berkeley. But what motivates me are the students who tour that court. So let's talk a bit about what justice is. It is both substance and appearance. It is the quality of the decisions we issue, and read my opinions, look at my history. I have one of the highest rates of affirmance as a trial court judge by the Court of Appeals in the Supreme Court. I almost never got reversed. So look at the quality of my work, and I assert to you that I am highly qualified for this job. So look at that, but also let's talk about appearance. Let's talk about appearance. We've alluded to it already. If we see a decision on a close issue, a controversial issue of race, and there are no people of color on the court, will it get less legitimacy? Will it support the outcome and the rule of law where we've all agreed to abide by the decisions of our court? That's the contract that we've all entered into, isn't it? We've agreed to respect, whether we like it or not, the outcome of the court and not take matters into our own hands. We're failing in that regard when there's a lack of legitimacy on our courts. So it matters both for substance and for appearance. And it matters because when you have a diversity, and whether that's geographic or gender or ethnicity, it adds to the discourse and the quality of the discussion on the court. I assert to you it is very, very important. I want to make sure that I'm conveying to you my confidence in this nation and the rule of law and the promise that we're all equal before the court. We've taken that oath, each of us who's a judicial officer, and we believe it to the core, to the core. In our Constitution, the preamble starts, "We the people of the United States, in order to form a more perfect union." And here's the important part, right? Because we're forming a more perfect union. How are we going to do that? Establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. In our Constitution, justice comes first. It's the very first thing we note. Why? There won't be tranquility without it, and there's less to defend if we don't have it. It is fundamental to our democracy. And fundamental to our democracy is having an informed electorate, and that's where you come in. Teach the people about the voting. In this vote for the Supreme Court, I'll be on the ballot in the primary. People don't know me. They don't know my opponent. They're faced with two names. That's why that poll about name recognition and discrimination is so important. There's going to be no voters pamphlet from the Secretary of State for budget reasons. So some counties will publish their own, many will not. The voters won't know, and they'll vote based on the names. I need you to get the word out. And if you disagree and if you think my opponent is more qualified, so be it. But let's make sure that each voter has considered the candidates and makes an informed vote. That is democracy. I'm probably going over my time. I know that others want to speak and have important things to say. Let me finish with the final refrain of America the Beautiful. America, America, God mend thine every flaw. confirm thy soul in self-control and thy liberty in law. Thank you.
Okay, our next panelist today is Judge Cameron Mitchell. Judge Mitchell was appointed to the Superior Court of Benton and Franklin counties in 2004, the first African-American appointed to that court. He is also currently serving as the co-chair of the Juvenile Justice Advisory Board for the state of Washington. Prior to his appointment to the Superior Court, Judge Mitchell served as an industrial appeals judge, hearing cases involving workers' compensation, crime victims' compensation, and appeals of safety violations. He also served as a judge pro tem at the Benton Franklin County Juvenile Justice Center, handling cases involving at-risk youth. Previous to this, Judge Mitchell worked as an assistant attorney general in Kennewick and also at the U.S. Department of Energy. Judge Mitchell received his bachelor's degree in history from Washington State University, go Cougs, and his law degree from Willamette University in 1986. Most recently, he was awarded the 2012 Martin Luther King Spirit Award by Columbia Basin College. Join me now in welcoming Judge Mitchell.
Before we came into the room this afternoon, there was a discussion about who was going to go first as far as the speakers went, and I kind of stood back and didn't say anything. I figured that wherever they want me, that was fine. But now after listening to the first two speakers, I kind of wish I would have gone first. So I'm very excited to be back here in Pullman and back on campus at WSU. I have a lot of great memories from WSU, but also a little bit reminded of when I was actually in school here, and the first time I had to stand up here and give a speech in front of some of my fellow students, and some of that nervousness, I guess, is still with me, so I apologize. And I hope that you'll bear with me, and also that I have something that you all might find worthwhile to say. We were given a number of suggestions of things we might want to discuss regarding judicial diversity, and a few of those topics were, in your view, what is the relationship between a diverse bench and the quality of justice? Should or can judging in the law be blind to such questions? What is the relationship between diversity, judicial legitimacy, or public support of the courts? And what are appropriate and inappropriate ways to seek greater diversity on the bench? And also, does an emphasis on diversity jeopardize judicial quality or merit? And there are a few others, but those are some of the things that I'm hopefully going to try to address, at least from my point of view. And unlike Dr. Gibson, my comments are going to be made basically based on my experience and from my own personal philosophy. I don't really have any studies or graphs to put up to back my statements, and I apologize for that, but I am going to give you at least my thoughts. And I would agree with Justice Gonzalez that diversity on the bench is very important to the public's perception of legitimacy of courts and also to the effectiveness of the courts. And I think for the two reasons that Justice Gonzalez, or at least in the two ways that Justice Gonzalez referred to in regard to the appearance and also as far as the actual substantive decision-making that the court has to make. Now, I have had the opportunity over the last couple of years to be involved in the Juvenile Justice Advisory Committee, both in the state and also our local Juvenile Justice Advisory Board. And during those experiences, we've had an opportunity to go out and speak with some of the focus groups that we had from various minority groups, the Latino community and the African American community in the Benton Franklin County area in particular. And both of those groups express the concern that when they are first could become involved with the courts. And again, unlike Dr. Gibson, I'm going to be referring to the trial court level, particularly Superior Court. And for two reasons. One, that's my experience, and the other reason being that I think that's where most people have the most direct contact with the judicial system and with judges in particular. But both of those groups indicated that when they first come to the court, particularly the juvenile court, and they see the people working there and they don't see anyone who looks like them or looks like they might have the same type of experiences that they may have had, that is a very intimidating situation. And they feel immediately excluded rather than included in the process and in the system. And that, to me, I think is very concerning. From that very beginning, they feel that they're at a disadvantage and that their likelihood of receiving justice is diminished simply because of the appearance of the lack of diversity in the system. And obviously that's beyond just the judges, but all the folks involved in the legal system. And those groups also indicated that including more diversity in the people involved in the system has just the opposite impact on them. They do feel more that the system is more inclusive and their expectation of receiving justice goes up. So I think it is that appearance is very important. It certainly sets the stage for how the rest of that interaction might unfold. And having said that, I guess it also, has some pitfalls as well, because I think if in fact that were to occur, and we were to have more diversity throughout the judicial system, and those expectations are beginning to rise, as people move through that system, if in fact that expectation is not realized, then I think their opinions regarding the legitimacy of the court is going to suffer and may even turn more towards resentment. So I think it's important that the appearance be followed up with the actual substance. And one of the issues that has been widely talked about, I think both in our state and throughout the country, and Justice Gonzalez alluded to it, is the disproportionate contact that minorities have with the judicial system. A lot of those studies are centered around the juvenile court and the fact that youth of color are much more likely, one, to be coming into the system, two, once they are in the system, they are much less likely to be given alternative options such as diversion, and that once into the system, their stay in the system is much greater than youth of the white community. Obviously, there are numerous causes for that are hard to ferret out and hard to understand. And there's a lot of research ongoing in that area, but certainly that is something that is of concern to the courts. And the research has shown that judicial leadership in making changes to those situations is very critical. And while simply having a diverse bench isn't necessarily going to make those changes, diversity on the bench, at least in my opinion, would lead to at least the opportunity to have a better understanding of some of those situations, some of those causes, and hopefully to some leadership in trying to correct those things and making our system more blind to race, ethnicity, and other minority characteristics. The other area I think where diversity on the bench is something that is very critical is in regard to the substantive areas. And we talk, at least it's my opinion, that oftentimes when folks talk about whether or not we need diversity on the bench and whether that dilutes the quality of the judges that are on the bench, we focus frequently on the adult criminal system. And in that system where the laws are set out very clearly, and the determination of guilt or innocence is one that should be objective, should be applied equally to all people. But that is only one very small part of the, although important, very small part of what judges, at least in the superior court level, do and the decisions they make. The judges in the Superior Court are often, involved in family law decisions. They're talking about or trying to decide what's in the best interests of children and families and try to get the best outcomes for children. And quite often in doing those things, I think it's important to have a culturally competent bench that can understand some of the cultural nuances, some of the strengths, some of the challenges that face various peoples of different cultures, different ethnic groups, different genders, and how they can best fashion a decision that's going to have a positive impact on helping that family to move forward in a positive fashion. I think having diversity on the bench, people with diverse experiences, diverse backgrounds, and diverse cultures, allows the bench to be more responsive to the real needs of the people that they have to make decisions regarding their lives. That same those same attributes would apply to the court in the juvenile court system, where we have kids who are there either for dependency matters or offender matters, where in the dependency matters the court is trying to, again, fashion some type of services, some type of sanction, make some type of placements that's going to allow the family to be successful. And again, being culturally competent is important to making well-informed and effective decisions and helping those families to come together and be reunited or to address what issues they may be facing before the court. In the criminal arena regarding juvenile court, once there has been an adjudication, then the court, unlike the adult court, the goal there is to try to come up with some type of services, some type of sanction, some type of provisions that are going to help that juvenile, when they leave the system, to have the best outcome, both for themselves and for society. So it's much more of a remedial type of situation, which again requires, I think, a lot of cultural awareness to understand what challenges these youth are facing, what strengths and weaknesses their communities have, and what is in fact going to be the most successful in helping them to succeed. So I think that diversity on the bench, while not the only solution to those issues, is something that certainly would assist the court and be more effective and more efficient at dealing with those issues. As Justice Gonzalez was indicated before, I wholeheartedly agree that no judge should be appointed or be elected solely for the fact that they are going to add some diversity to whatever bench they may be being appointed or elected to. The decision should be made based on that individual's qualifications and their own personal merit. But diversity should not be an impediment to that appointment or election either. And certainly, experience and background are qualifications or qualities that the electorate needs to evaluate in determining whether or not a candidate is in fact well qualified or not well qualified to sit as a judge. And by saying this, I don't mean to insinuate or infer that only people of color or or people from other more diverse backgrounds are capable of making good decisions in regard and becoming culturally competent. I am, as a lawyer, had the good fortune of practicing law before two gentlemen, Commissioner John Carroll and Judge Dennis Ewell, both of whom I don't think could be referred to as culturally diverse. Those two gentlemen, I thought, exemplified the effectiveness and the desirability of becoming and applying cultural competence in making judicial decisions. And quite frankly, I'm sure I would not be a judge this time without either one of those gentlemen's influence. But I do think that a culturally diverse bench helps perhaps to flatten that learning curve a little bit and to allow the issues of cultural competence to be more freely and more effectively addressed. And I also believe that being a member of a bench and the judiciary in general is a situation that allows you to learn from your colleagues. And I think having individuals of diverse backgrounds on the bench allows all of us to learn more about cultural competence and to be more effective and more efficient in the decisions that we make. And I think ultimately the quality of the decisions and the justice that we administer is what is most important in establishing the legitimacy of the courts and the judiciary. I think I went a little longer than I intended, but thank you all for your attention.
Of course, in putting together our panel today, we gave a lot of thought to the question of diversity on the panel, and by that I mean diversity of the level of courts. We've now heard from a Supreme Court justice, from a trial court judge, and our next panelist is on the Court of Appeals in the state of Washington. Judge Laurel Siddoway was appointed to the Division III of the Washington Court of Appeals in May of 2010 and currently serves as the acting chief judge for that division. Before joining the court, Judge Siddoway served as the managing partner of the Spokane law firm Randall Daskin. And as a trial lawyer, she represented both plaintiffs and defendants in many types of business litigation, including complex litigation, defamation and First Amendment matters, and civil rights litigation. Judge Siddoway graduated with a degree from philosophy from the University of Utah in 1975, where she also later taught in the Department of Philosophy before eventually obtaining her law degree in 1979. Judge Siddoway also holds an LLM in taxation from New York University. Join me now in welcoming Judge Siddoway.
Thank you. It's a pleasure to serve on the panel with my colleagues on the bench, and in the case of Justice Gonzalez, my superior on the bench, as well as Drs. Clayton and Dr. Gibson. And I'm so impressed by your turnout today on a Saturday and for your appreciation for this, what I think we all agree is an important subject. As indicated, I serve on Division III of the Court of Appeals. Division III is that division of the court that serves all of the counties east of the Cascades. And although we're the geographically largest division of the Court of Appeals, we're, of course, the least populous. There are 5 judges on the Court of Appeals, and when we decide cases, we sit in panels of 3. On my court, of the 5, 2 of us are women, and my 3 male colleagues I regard as very enlightened gentlemen, and it's a pleasure to serve with them. The role of the Court of Appeals, let me tell you a little bit about that before I share with you my perspective, really focusing on gender diversity, because that's my experience, not only in the 2 years I've had on the Court of Appeals, but in my many years of trial practice before that, which was in both federal and state trial courts and appellate courts. But the role of the Court of Appeals is that we are the only appellate court that most litigants have, will ever see, and for that matter, will have the right to go to. If you try a case, if you're a party to a case in Superior Court, which is our trial court of general jurisdiction, you can go to the Court of Appeals as a matter of right if you're not happy with the result. But if you're not happy with the result you get in our court, you can only go to the Supreme Court if the Supreme Court wants to see you. And Justice Wiggins, in a presentation we made earlier today, confirmed my recollection when I was practicing law. What I used to tell clients is that your odds of having the Supreme Court take a case from the Court of Appeals are only 1 in 10. So really, our court exists to be the court at which somebody can have a shot of having prejudicial error corrected. The Supreme Court is really watching for cases that are going to clarify and advance the law more than correct mistakes made in individual cases. I bring you good news on gender diversity from the Court of Appeals. The Court of Appeals, all of the divisions, there are 21 judges right now serving in the Washington State Court of Appeals. Of that, 10 are women, so we're 48% of the judges on the Court of Appeals are women. The Supreme Court is almost as good. They have 4 out of 9 judges that are women, so their statistic, I guess, is about 44%. I do want to put a word in for my colleague on the Court of Appeals, Judge Kulik from Wenatchee. Some of you perhaps know her. Judge Teresa Kulik was the first woman appointed to Division III of the Court of Appeals. She's up for election this year, and she drew an opponent. So either when we're done here this afternoon or this evening, I would love to talk to any of you who are from District 3 of Division III about what an outstanding appellate judge she is and how important it is that we keep her on the Court of Appeals. Our statewide statistics for gender diversity in the trial courts is not as good as it is in the appellate courts. From the statistics I saw that are apparently current, 34% of our Superior Court judges are women, and 32% of our judges are district court judges. But I'm convinced that those statistics will improve as more women lawyers reach an age and experience level where they are viable judicial candidates. I look back at when I graduated from law school in 1979 from the University of Utah, only 15% of my class was women. And now I hear that over 50% of the classes of most law schools are women. So I have every confidence that with the passage of time, there will be a larger pool of experienced women candidates, and the statistics in the trial court will continue to grow. And of course, this is such a sea change from the representation of women in the practice and on the court when I was in college, headed for law school, graduating from law school, and beginning as a new lawyer. We can recall easily in that era that if a woman was a party to a lawsuit, if she was a victim of domestic violence, if she was being prosecuted for a crime, if she was going through a divorce, she would go to the trial court, and her trial court judge would be a white male. And if she wasn't happy with the results she got in the trial court, she could take it to the Court of Appeals, where her appeal would be heard by 3 white males. And if she wasn't happy with the result there, she could take it to the Supreme Court, where her case could be heard by 9 white males. So it really is a sea change. But I want to suggest to you that I think the change is more significant than just the numbers, because as I prepared for today's presentation and kind of thought about the ways that I think diversity, even as it's just beginning, the courts are becoming more diverse, it percolates through the system. It's felt in ways that are more significant than necessarily the perception of legitimacy. And I'll tell you some examples that I came up with. The more women you have as judges, or for that matter, the more people of color that you have as judges, judges communicate with each other. They jointly administer their courts. They meet, they talk. Even judges at the trial court level that preside individually over their cases confer with colleagues about their cases or even talk with their colleagues afterwards about cases. And every time you increase the opportunity for judges to have that kind of interaction with other judges that bring different life experience and different cultural backgrounds, that's good for everybody on the bench. One example in the administration context is judges establish either formal or informal standards of conduct for their courts. And as you have more and more judges on the court that bring different backgrounds, different cultural competence, the standards for conduct change and they get enforced. It just does not happen in court anymore that you had the discrimination in the treatment of witnesses that I saw, that I experienced when I was a young lawyer, where men in the courtroom were referred to as Mr. or Doctor, and women in the courtroom were referred to by their first names, and heaven forbid by some diminutive, like honey or sweetie. And that just doesn't happen anymore. And it also doesn't happen. Judges understand now that they have to treat all judges, or excuse me, all lawyers that appear before them with equal respect, whether it's a 60-year-old male attorney or whether it's a 30-year-old female attorney or an attorney that's a person of color. When parties take their appeals, there is a very good chance that although you may not have had a woman judge if you're a woman at the trial court level, or you may not have had an enlightened male judge, and certainly there are plenty of those, don't let me suggest that there aren't, you have very good odds that your appeal, there will be participation in your appeal by a woman. At our court, your chances are 60% that the panel that hears your appeal is going to have one or more women on it. And if you get to the Supreme Court, since they decide to take cases as departments of 5, and of course they hear the case as a panel of 9 in the entirety, you've got a 100% guarantee as a woman that when the court considers whether to take your case, there will be women in that conversation. And when the court ultimately decides the merits of the case, there will be women involved in that conversation and that decision. I would submit to you that as the bench becomes more diverse, it raises the sensitivity of the lawyers that practice before the court. And they carry that from a trial they had before a female judge or a judge of color into other cases. Because I will say, I like lawyers. I know not everyone likes lawyers, but I like lawyers. I practiced with lawyers for years. And I think the vast majority of lawyers want to be culturally competent. As they gain cultural competence, they embrace it. And they exercise what they've learned in every trial they have. It doesn't depend on which judge they're in front of. And even if you're more cynical about lawyers, good heavens, I mean, they appear before juries. So if you teach them something about cultural competence, unless they're morons, they're going to remember it when they're participating before a jury. And of course, in most trial courts, and I can't speak for all, but certainly Spokane and the trial courts in which I've practiced, there's no guarantee that the good old boy that is the judge assigned to your case is going to be the judge that actually presides at trial or ends up hearing important motions. Judicial assignments change. The judge goes off the criminal docket to the civil docket or vice versa. Trials get delayed. It pushes it into the court of another judge. You show up the day the case is supposed to be tried, and the judge to whom you're assigned has 5 other cases, and some have priority over yours. You're going down the hall to some other judge. So lawyers have to prepare their cases not knowing which judge they're ultimately going to try the case to. In terms of the development of the law, not only does diversity on the bench affect the development of the law in terms of precedential decisions that get made by Justice Gonzalez at the Supreme and his colleagues at the Supreme Court and by my colleagues at the Court of Appeals, but there are informal and formal channels by which judges talk to legislators about changes in the law that they perceive from proceedings that go on in their court, changes that they see that need to be made. And the more diverse the bench is, the more diverse are the parties that are having that conversation with the legislature. And then finally, this is sheer speculation on my part, but I think it's probably true. And that is that I think greater diversity on the court empowers jurors who may not have felt empowered before. And I think back particularly, imagine being a woman serving juror duty in the 60s, and you show up and there's a white male judge and white male attorneys in your court, and when you take the lunch break or are wandering the hallways, every judge and every lawyer in the court is white male. How does that make you feel when you go into deliberations? Do you feel like you're an equal participant in that process? I don't know. I suspect that as jurors participate in trials and they see women, they see people with different backgrounds, they see people of color participating in the trial, it supports, it validates the fact that they are equal participants in that process. And it makes them feel more powerful, and if they were otherwise reticent in the jury room, I've got to believe that it makes them feel more confident in being equal participants in deliberations. So for all of those reasons, I think whether we're making the rather substantial steps we've made in gender diversity in Washington State at least, or regrettably the smaller steps that we may be making in diversity in other ways on our courts, every little bit helps. And lastly, I just want to thank the League, and I was going to thank the League on behalf of women judges, but after hearing Justice Gonzalez, I will thank the League on behalf of him as well, because I think for someone who is making a hard decision to take the risk of giving up a legal practice or another legal career to become an elected judge, the financial risk, the professional risk, it's very helpful to know there's organizations out there like the League who are encouraging participation, who are providing forums where every candidate can demonstrate his or her competence to the voters and who embrace and endorse the value of diversity on the bench. I really think it can be make or break for some people that are considering going on the bench to know that there is an organization with your long, steadfast service that's out there to support their candidacy, not directly, but their, let me say, their shot at being judge. It's very, very helpful. The work you do is very important. Thank you.
Well, since my friend Jim Gibson began this panel with Chief Justice Roberts' analogy to baseball and umpires, I'll continue with that analogy and talk about who's batting cleanup now. Our final panel member is Judge Douglas Robinson. Judge Robinson has served as a district court judge for Whitman County since 2001. Before that, Judge Robinson served as a municipal court judge, a district court commissioner, and frequently served as a pro tem judge in both the district and superior courts. Prior to taking the bench full-time in 2001, Judge Robinson was also a trial attorney who specialized in major criminal felony defense. Judge Robinson graduated from Pacific Lutheran University with a degree in psychology in 1973 and received his JD from Gonzaga University School of Law in 1978. He is a member of the Washington State Bar and is admitted to practice before the Federal District Court in Eastern Washington and the United States Court of Military Appeals. Join me now in welcoming Judge Robinson.
Well, the three topics that have been raised today are diversity, legitimacy, and accountability. And given my position as district court judge, I'd like to address those in the reverse order. The accountability aspect comes into play in my daily contact with the people who come before me. Whereas the superior court, the appellate court, and the Supreme Court are ones that people rarely go to and probably will never step foot in. it is entirely likely that you'll come and see me at some point. The district court here in Whitman County handles about 9,000 filings a year. I handle between 600 and 700 minors in possession of alcohol alone. So I see a lot of folks. And when I go through the checkout line at Safeway, it's likely that they're going to recognize me. And that's happened more times than I can remember. Not necessarily at Safeway. But when I started my time on the bench, I went forward with the position that I was going to give everybody their day in court, whether they won or lost, whether they got what they felt they wanted. They were going to know that their case was heard, that everything they said was presented correctly or considered, and that I expressed to them the reasons for my decision, so that when they leave, they know why the decision was made, they know that they were heard, and that they know that they had their day in court. If you have that kind of contact with folks, if you have that kind of exchange with people and give them that kind of time, then I think it increases the legitimacy of the court. Again, everybody can't win. You might come to me with your overtime parking ticket from downtown Pullman, and you end up with a $5 fine instead of $10. Well, that was because you were heard, your case was considered, and an appropriate adjustment was made. But I could not avoid the fact that you did violate that overtime parking requirement. So there are requirements that all judges must comply with. We must apply the law, but we can adjust the penalties based on the situations. So when it comes to accountability, the court has to be accountable to the people that it serves, and if that accountability is expressed in terms of thorough consideration of their cases, then I think that they go away satisfied. The legitimacy of the court is based largely, I believe, on how the people are treated. Anybody who has not come before the court can only judge the legitimacy of the court based on their perceptions. It is the actual having been there, done that, and coming away with a decision that allows them to make an educated estimate of the legitimacy. And I would love to see a study, Dr. Gibson, of people who have come before the court, a study of people who are in prison and asking them whether they feel like they were treated fairly, whether it made any difference whether the judge was male or female, minority or white. If the person feels like they were treated fairly by the judge that they saw, I think that they will express a positive opinion. Others will not, regardless of the judge that presided over their case. But again, how a person is treated, I think, is the important factor in determining the legitimacy of the court. Little can be done about perception by those who have never been to court, unless you adjust the gender makeup or racial diversity of the court, perhaps artificially. In Washington, when I go to judicial conferences, when I go to conferences conducted by the National Judicial College or any number of other forums, I look around and I see a wonderful diversity. I've never counted heads, to be quite honest, but I always have been under the impression that about 50% of the judges appearing at any conference I've been at have been female. And there is a large percentage of minorities. I'm dismayed to hear what Justice Gonzalez has said about the simple fact of the Hispanic surname. I quite frankly was astounded by that, and I would like to think that we were better as a people than that. But that gets back to the voter. That gets back to the person who is perceiving the court or the candidate. And that is something that we have to continually work on. And I hope that in the months and years ahead that will correct itself. But one of the things that wasn't mentioned is that I spent 30 years as a military lawyer. My first full-time job at a law school was as a judge advocate with the Air Force. After 5 years of active duty, I went guard and then reserve and then back to guard. But so I've been in that environment for a long time as well. And again, diversity never was an issue. It was just a reality. In the JAG class that I went in, fully 50% of the candidates were women. And we had a good percentage of minorities. The upward mobility opportunities for women lawyers and minority lawyers in the military is equal to that of whites. It was never an issue. And in my practice, I never understood why that should be an issue. When people come before me, I realize there's a difference in people, but those differences go well beyond gender and race. If somebody comes before me who is from Kirkland or from Bellevue, that person has a much different perception of things than somebody from Asotin County or from Newport or from Montana or Boise. And those differences have to be taken into account as well. And again, you have to listen to what people are saying. You have to listen to how people phrase things and adjust your presentation accordingly so they know you understand where they're coming from. And we can't always get it right, but I certainly work hard to do so. One of the things I hear frequently is people coming over from the west side who get an infraction on Highway 26, which for most of you is past the fairgrounds there. They say, well, it was a freeway. I thought, freeways over on the west side are 70 miles an hour. So we don't have freeways here in Whitman County. We only have 8 miles of 4-lane roadway, for crying out loud. So you got a big difference there in how people perceive things, and you've got to discuss that with them, let them know that you understand that. But as far as diversity on the judiciary goes, I'm satisfied that we are headed in the right direction. We have an outstanding judiciary in this state, and we have a great many very capable women and minorities who are outstanding lawyers and judges. Judge Siddoway was talking about the makeup of the genders in the judiciary in the state of Washington. I have no idea what it is statewide, but in Spokane County, where I go on a regular basis, I believe there are 8 district court judges and 4 of them are women. And in the Superior Court, I believe that the split is almost equal as well. And it always has been. In Whitman County, where we've got 1 judge at the district court, by definition, you can't have diversity, I guess. It's all one or the other. But generally speaking, across the state, I think we're doing very well. And I think that natural progression of good lawyers into being good judges is something that we certainly need to encourage. Any disability that a female attorney or a minority lawyer would be under because as far as their consideration for a judicial position is entirely inappropriate. And I hope that, as I said, that as things go forward, we lose that. And the best person is always the one selected for the position. Thank you.
Okay, we have about a half an hour now for questions and answers from the audience, and perhaps I'll begin. 4 years ago when President Obama was elected, McCune Miller magazine, which is a magazine that tries to popularize academic research, asks several academics to write short letters to the president asking or proposing what they think is the most important thing that he should do as president. And for some reason I was selected to do that. My letter basically asked the president to pay much more attention to the diversity of the federal appellate bench, in particular the Supreme Court. But the diversity I was talking about had nothing to do with race or ethnicity or sex. It had everything to do with the fact that we now have 9 justices who are all basically lawyers, academic lawyers. None of them have been elected to office. They don't know how to think about, for instance, how Congress or the executive branch operates in the sense of elected officials. And so I think they've made some really terrible decisions with respect to election law, because I don't think they understand elections. Now, my only point is this: have we focused too narrowly on the question of what we mean by diversity by focusing mostly on race, ethnicity, and sex? And are there other aspects of diversity we should be concerned about with respect to the state courts?
What we are you referring to? I mean, I'm not sure who's making the focus. I think diversity is in the eye of the person defining it, and that's one of the problems. We talk about it, we don't often know what we mean. We're not talking about it on the same level. Diversity matters in a whole variety of ways, and I think it improves the discussion, as Judge Siddoway was mentioning in her remarks, when you have that kind of a mix. Think about it in the context of something that might resonate here. When we had a panel of doctors talking about women's health, and they were all men, did you pay attention to them? Did it undercut the legitimacy of what they said? Same thing happens on the courts, right? The exact same analogy applies.
Well, speaking of the Supreme Court, be careful what I say here, but we were talking last evening about the fact that there's nobody on the court that's a Westerner. There's nobody that's graduated from law school other than Yale or Harvard, and I really do think those things need to be considered, and I think there's been so much discussion of it that maybe it will be considered with the next appointment.
And going back on the issue of women, there were 8 of us who were finalists for the appointment to the Supreme Court position that I received. Seven men and 1 woman. I don't think it's a coincidence that men are more willing to put their names forward and compete for those spots. We're still in that situation. Right now, there are 9 candidates running for the 3 spots that are going to be on the ballot for the Supreme Court. 2 of them are women, the rest are men. I don't think this is a coincidence. I think we need to do more to encourage women and people of color to run. It doesn't mean changing the standards, or if people say we're lowering the standards by diversity and we're affecting legitimacy. If the legitimacy is undermined because of people who have biases, who cares? But the point is, when you increase the diversity, you do it by encouraging people to put their name in and compete, not by changing the standards. You help people who are qualified to compete, and to compete in a way that rewards merit. You get rid of the myth of the level playing field, and you actually create one.
This is addressed mainly to Professor Gibson. Do you believe that diversity is more likely to occur with appointed or elected judges?
Ironically, the one slide you didn't see actually addresses precisely that issue. And what the data show is that historically, minorities and women have not profited from so-called merit systems, from appointed systems. But today, there's absolutely no difference across the different kinds of systems. That same article where I got the overall data looked precisely at that question of whether appointed, partisan, nonpartisan, and retention differed, and there's no difference at all.
It's an interesting statement, because when we look at the state of Washington, there's never been a Latino elected outside of King and Pierce County to a judgeship, not once in the history of this state. There's no Asian judge. I'm sorry, that's not true. There are 2, I think, elected outside of those 2 counties. Very unlikely to get elected. Now, what happens when there's an appointment to a vacancy? That's happened once with a Latino, and then he lost an election. So we have a real problem under either system right now, appointing and retaining. It does matter, I think, what the system is. And whether appointment or election is better, I think I'll have a really clear opinion about that on August 8th. But each system has its problems, doesn't it? If we have racially polarized voting, that's a problem with election, especially if we call ourselves a democracy and we don't send out a voter's pamphlet. If we have an appointment process that's not fair and equitable in terms of who's on the panel and what qualified means, we'll have the same problem. The point is information and an informed democracy, and that's the whole point, I think, of the League.
I'm particularly interested in the very idea of legitimacy, because your chart that showed that white respondents, their feeling about the legitimacy of the court was reciprocal to whether they thought that there were black people on the court. And I just think that there's a certain kind of questioning of the legitimacy of the people who are asked the question. I think that one of the things that's happening, that happens in public these days, is that there are certain people who are allocated the privilege of saying what's legitimate. And when you speak about whether or not the person who came before you in the court found you legitimate, that's very different than a survey of a kind of public that has the power to say someone is legitimate.
I don't exactly follow the logic, but we do know that courts around the world vary enormously in the amount of legitimacy that they have. We do know that the Nigerian Constitutional Court decided their election and it was burned to the ground. The same has happened in Pakistan. That's not the case in the United States. The U.S. Supreme Court has such a deep and broad store of legitimacy. We actually call it a reservoir of goodwill, that court can get away with making decisions and people will respect and accept those decisions. Now, I would be loath to disregard or disallow any person from participating in the political process because I don't approve of their attitudes on an issue. So I think we do have to worry about people who have prejudice. We can't simply disregard them and exclude them.
One part of diversity that you never mentioned was religion. And what has bothered me is all the Catholics on the Supreme Court. I mean, it's a majority.
I'm trying to do something about that on the state Supreme Court.
You know, people in New York complain about diversity on the U.S. Supreme Court as well because no one from Staten Island is on the court.
I'm curious about the statistics about men and women and others who throw their names into the ring, and I'd like to hear a little more about what kind of conversations are happening in the beginning of the process, reaching out to potential nominees or applicants, and whether those conversations are happening at the levels of those who may be inviting potential applicants or encouraging them, and whether those systems are periodically evaluated by an oversight committee or any kind of people charged to talk about some of these issues, kind of starting from the maybe root of the cause there.
It's part of the consideration for most candidates who are talking to political consultants and going through that preparation process. You're likely to be told by the consultants that if you are not heterosexual, you're more likely to get a challenger. If you're a person of color, you're more likely to get a challenger. And therefore, it's more expensive and more risky for you to put your name in for a judicial position. And that you'll likely have to put in your own money to hire consultants and pay for mailings to keep the job. So not only is it riskier, it's more expensive as well. And it's a significant amount of money to run a judicial race. And then, of course, when you raise and spend money in a judicial race, people accuse you of being beholden to special interests. So there's no winning in that effort. It's a very complicated and difficult subject, and it dissuades a number of women, gay and lesbian candidates and people of color, or frankly, people whose name just sounds different or odd, they get the same sort of advice and treatment.
There's almost two levels of dialogue that goes on. I'm not sure whether it's the administrative office of the courts, but some branch of the courts actually puts on a presentation every year that's well publicized, or every year there's going to be a judicial election, basically providing the nuts and bolts information you need to know about how to seek an appointment or how to run for a judicial position. But the real hard conversation comes when you talk to the political consultant, or in my case, when I was interviewed by Governor Gregoire, and at a time when her popularity was not high in Washington, and my district of Division 3 is very politically oriented the other way. And so there was a very candid discussion about the fact that I would probably have a contested election, and was I prepared to run a contested election in a district that was not favorable to me demographically. So, you know, that's the hard conversation you have.
And by the way, I'm endorsed by the next governor. I'm endorsed by the next attorney general. That's because both of the candidates in both of those races have endorsed me. That's how I think good my record is. And I know I'm bragging again. But we're going to have a contest, and if it's on merit, I win. And the question is, will it be on merit?
Kind of addressing, I think, your question regarding if there's someone out there to provide guidance or oversight to people who are maybe considering becoming judicial candidates. I think Judge Siddoway did refer to I think it is the Administrative Office of the Courts who prints on those seminars, if you want to call them seminars. Justice Gonzalez and I had the opportunity earlier this year to be involved in a conference that was put on at Seattle University School of Law, where they brought together a number of judges and invited various people who might be interested in becoming judges, to allow them to hear from the judges what they believe it takes to become elected or to be appointed, and actually what the job entails if you're fortunate enough to be elected or appointed. And I think things of that nature can be very helpful, and I hope at least that experience was good for those individuals. And there was, how many, I don't know, 50 or 60 folks who came to participate in that. And I think those types of things are one way that folks can learn maybe what it takes to run a campaign, or to seek an appointment, or to actually perform the job. I also think that those types of things are critical to broadening the access and the opportunity of people to become judges, which I think in itself will help in the efforts to diversify the bench.
So this leads me to express my experience in the league in dealing with voters, that they're utterly baffled by trying to choose between candidates for judicial offices, in that they have little or no basis for which to make an intelligent decision. And that's okay, in my opinion, at least the way we do our elections here in Washington. And I'm from Oregon, and we do the same thing down there. But it leads me to the question, is there some effect on the way we elect our judges on the quality of the judicial decisions that come out the other end? Would there be a better system of conducting our appointment and election of judges, such as the appointment and judicial retention elections that are carried out in the Midwest in some states?
Let me say one thing before. I think probably the professor would have a view on that. If you come away with nothing else from today, take a look at www.votingforjudges.org. Votingforjudges, one word, .org. And this is not for me, www.votingforjudges.org. It is a web page that doesn't take a position on any candidate. They're not advocating for anyone, but it's one web page for the state where you can go there and click on where you are, and it'll give you your ballot and give you the information on each candidate running. So you can make an informed vote about judges in this state. It's one way to make it easy for voters to do the right thing.
I'll give you an answer about how to unbaffle voters that you won't like, and that is change to a partisan system. Because the one thing we know about judging is that Democrats and Republicans behave dramatically, and I mean dramatically differently on the bench. They make different decisions, they have different values, they implement those decisions in different ways on the bench. We've got so many studies showing this. So if I'm a voter and I have difficulty getting information, in part because it's been banned by bar associations until Republican Party of Minnesota versus White, but if I have trouble getting information, the one thing that I should be able to rely on to make a decision to make sure that I get a conservative judge is I've got to know their party. And so if you want voters to be informed, partisanship is by far the cheapest method to allow judges, to allow citizens to make rational choices. Well, there are more expensive ways too, and so this flood of money that y'all don't like either actually is money that has a dramatic impact in informing voters about the qualities of candidates. You see, I fundamentally disagree with Justice Gonzalez, because everything he's talked about has to do with qualifications. I think the key thing that distinguishes judges is their values. And those are the kinds of things that voters want to hear about. You don't have to be a genius to decide Roe versus Wade. Being trained at Berkeley or wherever doesn't make you a better arbiter of Roe versus Wade. These are value judgments. The voters want to know, and therefore anything that we can do to give them information about values, I think is useful.
And I think the professor's assertion is ridiculous, in a word. And let me say why. I think he's probably right that it's easier for people who are voting to know a party affiliation. I don't happen to have one, so I don't know what you take away from that. I've never been involved in partisan politics. It's just been the way I was built. But I think it's an easy out for people actually to think deeply about who the best candidate is. I think it would undermine the very basis of the judiciary, that we're not supposed to be making political decisions, and that you can't predict how we're going to rule on a given case by a simple dichotomy of party affiliation.
I'm afraid you can, and I can cite evidence to the max.
Well, and I would say, and maybe this is more true of my court than the Supreme Court, which really does take cutting-edge questions, but judges decide many cases where it would be a stretch to suggest that a value judgment is being made. The decision just really doesn't have anything to do with values. And again, the Supreme Court is probably different in that they're actually looking for questions that presents those tough issues. But no, there's a lot of work that judges do that I don't think can be fairly characterized as presenting value judgments like that.
I think that really applies to the trial court level, in my opinion.
I'd just like to do, is that on? Okay. I'd like to do a little quick poll of the audience. I'll tell you what I do when it comes to voting for judges, or what I've done in the past. I don't think I will now because I'll be too embarrassed. But I call a judge that I know and respect, and I say, you tell me who to vote for in this election. And then I tell about 75 of my closest friends every single election. How many of you do something like that? Show me your hands. Okay, we need something like this, www, if that's the legitimate source for information. We need a decent bunch of information. And the president of the State League is holding up something, and I'm obligated to read it. It says, vote and the choice is yours, don't vote and the choice is theirs. Oh, our vote, I'm sorry, the League of Women Voters has a voter. My pay has just been cut on the state board.
This question may seem a little flippant. I really don't intend it to be, but the question about legitimacy and how people feel about the court. And I think it was Professor Gibson who said that the more people know about the court, the better attitude that they have, feelings they have for it. What about things like Judge Judy? Do you think this helps or detracts from our, people's attitudes and feelings about the court and about the court's accountability and listening to people? And any of you to answer.
Justice Gonzalez, I'll defer to you.
I think Judge Judy is entertainment. She can be funny. I would hope that judicial officers don't actually treat people as disrespectfully as she does sometimes.
And I'd agree. I think it's very, for me personally, I think it's offensive. I know it is entertainment, but for people to be given that as an impression of what the justice system is about is disappointing to me.
What about Judge Wapner?
I will warn you against one thing, however, because we see so often these surveys that say the American people can name more of the 7 dwarfs than of the 9 supremes, or more know Wapner than know Rehnquist or whomever. Don't trust those surveys one single bit. They're just simply wrong. And part of it stems from a practice at the University of Michigan that started long ago on how we code answers that are correct. So if we ask who is Rehnquist or who is Roberts, and you say he's the head honcho of the Supreme Court, that's wrong. If you say he's on the Supreme Court, that's wrong. If you say Rehnquist ran the impeachment hearings, that's wrong. Indeed, if you say that John Roberts is the Chief Justice of the United States, which is what he is, that's wrong as well. So we're fundamentally rethinking the levels of knowledge that people have, and these little surveys that are done comparing these fictional judges are just not worth a dime.
Professor, I had a question following up on your comment about partisan elections and identifying yourself as partisan. I'm just wondering if your research on legitimacy and how election increases legitimacy, if there are distinctions between nonpartisan, partisan, and retention elections in terms of creating legitimacy or increasing legitimacy.
That's a great question. To date, I've done this research in 2 states, Kentucky and in Pennsylvania. Kentucky's nonpartisan and Pennsylvania is mixed, but it's partisan for open seats, a retention for an incumbent. But in partisan and nonpartisan, we're getting pretty much the same results. Now, the question is retention. It's an interesting question because retention really is a sham election. I mean, if any other country in the world said, shall Saddam Hussein be retained, we would laugh him out of the room. It's an election that I don't know. I don't have the evidence. I readily confess. But I would be shocked to see that retention elections have this legitimacy conferring capacity.
So today we talked a lot about the legitimacy and electoral judicial panels. How do you guys feel on the people how they feel towards the legitimacy and who's actually voting? Because there's a lot of young voters and uneducated, well, there's not a lot of young voters and there's so many uneducated people. The studies, like the studies that you did, are they the people that are actually voting the judges?
Well, judicial elections vary enormously in turnout. If you take Iowa, the Iowa retention election of 2010, it was a relatively low turnout election. They vary enormously, and as with all elections, the key is turnout. Who wins is a function of who's able to turn out their troops. Now, we know a couple of things. One thing that we've rediscovered is that negative advertisements do not dampen turnout. Indeed, the argument is now being made that negative advertisements, which of course, if you really want to look at the dirty days, go back to the election of 1800. I mean, these have been around forever, but negative attack ads are actually much more verifiable and therefore convey more information than do positive attributes. And so negative attack does not dissuade people from voting. And then the last thing we know is that if you want to drive up turnout, spend more money. Now, I recognize that there are downsides to money. There are definitely downsides, and, you know, Citizens United, Citizens United could change everything. We saw it in West Virginia in Caperton versus Massey, but it could change everything. The upside, if you want turnout, spend a ton of money and you'll get it. If you want informed voters, spend a ton of money and you'll get more informed voters. But you may do so at the cost to other things that are valuable.
In Washington, we have mail-in ballots, and the turnout for even those that register to vote isn't necessarily real good. What is your research on mail ballots versus going to the polls? Or why would people not be able to open an envelope, mark their ballots, and put a stamp on it, and have better results?
Cornell, maybe you actually have some views on that.
On the mail-in?
Yeah.
No, I have views on why Democrats and Republicans are different about the law.
Because there's actually a study that deals with racial harassment cases, and it finds that race matters more than your party affiliation. And party affiliation, they used a surrogate, and that was the party of the appointing president when you were appointed. And they found that the difference was racial in racial harassment cases. The difference was gender in gender harassment cases. Party affiliation was much less significant.
You know, I actually don't disagree with that, because party affiliation is a surrogate for ideology. And so my question is, if I want to vote for conservative judges across the board, can I find that information at votingforjudges.org? Can I punch in the position on the Second Amendment? Can I punch in Roe versus abortion rights? Can I punch in capital punishment and find out what judge is, where judges stand on these issues? I probably will get in trouble, but I would rather doubt that that information is available on votingforjudges.org.
Because it's fundamentally flawed as a question. You can't decide a case based on the subject matter. You decide the case based on the facts as they apply and the law in that case. You can't just decide it that way, or you're not really giving a fair shake. If you have a judge who says, this is where I am on the death penalty, right? And then a case comes before that judge, and the judge actually reads the briefs and thinks, well, I shouldn't uphold the death penalty in this case. That judge has flip-flopped, right? If the judge then does exactly what the judge promised he or she would do, well, that judge didn't even pay attention and made up his or her mind before even hearing the case. That is not justice.
Certainly, let me just press you a bit more on this, because certainly we would admit that there are different ways, legitimate ways, to view the law. People legitimately have different ways of interpreting constitutional language, for instance. So we can have a legitimate disagreement whether the Equal Protection Clause allows affirmative action programs or doesn't allow affirmative action programs. And so part of what we want to consider as an electorate is, what do judges think about our laws, our Constitution? And obviously this has much more importance with respect to appellate courts and courts of last resort than trial courts. But is there a way to get at that kind of information without referencing party labels or ideology?
One of the problems I have with those kinds of questions, and I recognize that there are voters who want to have that information. That's the information they want to have. And my contested election that I had in 2010, that my my opponent very much wanted everybody to have to answer those kinds of questions. The problem you have is if you really are if you intend to do your job, if you intend to decide the case on the merits of the case, and if you provide that seemingly, well, a nuanced answer, I guess, an honest, a professional answer, you're dodging the question that voter wants to know, because they really want to know ahead of time that regardless of what the facts are, regardless of what the nuances of the case are, they want their candidate to vote a particular way on all cases that come through the court. So it just makes it very difficult to respond to those questions because, frankly, a voter that wants to answer those questions really isn't looking for a judge. They're not looking for a judge.
We have time for one last question.
It's not a question, it's just to remind everybody that the reason that the League of Women Voters is doing vote411.org this year as an online voters pamphlet is that one of the major reasons we are doing it is because the Secretary of State couldn't afford to do it. So there is an at least online statewide voters pamphlet being done by the League.
Thank you. I think our time is up. Before we thank our panelists, let me just announce some of you are here for CLE credits or CLJ credits. A few of your students might be here for extra credit. There's sign-up sheets for each of those out in the hallway. Just don't get them confused, or else lawyers will be getting extra credit in a class, and students will be becoming judges. So having said that, let me thank you on behalf of the League of Women Voters, on behalf of the Foley Institute. Let me thank all of you for coming out today, and join me now in thanking our panel.